Welcome back to today's episode of the Comp Effect podcast. Today, we're going to have a conversation about all of the issues that are surrounding remote employees. There's a lot of businesses right now that have people working from home, working in other states, and frankly, there's a lot of questions that we're getting that we want to talk with an experienced attorney about today who can help guide businesses. So today's guest speaker on the Comp Effect podcast here is Kent Smith, and Kent is the president and shareholder at Smith, Mills, and Schrock Law, located in beautiful Des Moines, Iowa. His focus is practicing on workers' compensation, insurance defense, employment law, and civil litigation. And I just want to thank you for coming on the podcast today, Kent.
Hey, thanks, Todd, for having me. Looking forward to a animated discussion about remote employees.
So before we bring people onto the podcast, a lot of times we just have a pre-meeting like, hey, what do we want to talk about? And for those of you that are listening, when Ken and I had our first conversation, I think we talked for probably close to an hour and it went by super fast and the information was absolutely fantastic. So we're going to try and rehash some of that today. But Kent's the guy and he knows a lot of stuff when it comes to workers' compensation and remote employees. So Kent, before we get started today, can you just give us a little bit of your background and the history of your law firm?
Sure. I've been practicing since 2005. I have somewhat of a unique background in law. In 2005, I started at a law firm where I only represented injured workers. So I started on the plaintiff side. So I did workers' compensation where I represented injured workers. I did civil litigation where I represented the harmed party. And then I did employment law where I represented individuals who had been discriminated by their employers. In 2007, I switched to what is now Smith, Mills, and Schrock Law Firm, and I became a defense attorney. So I switched sides. I was playing offense, and then I went to the defense. So now I represent employers and in the actions brought against them by injured employees, or in an employment law context or civil litigation context, the person alleging harm. So that's my background in terms of my practice experience at Smith Mills. We started the law firm, merged away from another law, our original law firm back in 2007 has undergone modification, so to say, but mainly the principles are still there, and that's we want our niche in the marketplace to be innovative, entrepreneurial, and client first and client forward, and that's we really tried to develop a community with our clients. We don't like to refer to them just as clients or institutional clients, like you hear law firms say a lot in this side of work. We try to build community, and so we call our client community, and we try to foster that type of relationship with the people that we represent, and it's rewarding. There's pros and cons to each side, representing either plaintiffs or being the defense attorney. But what I like most about being the defense attorney is that community of clients that we've developed. It's long-term. When you represent an individual, that you might live with that case for a year or two, and then it goes away, and that relationship goes away. With the defense work, my relationships expand over time. And I think that's really rewarding because you get to grow with the client and really see the cause and effect of your representation for them over the years. So that goes for every lawyer in our firm. They're client forward, and we really try to develop community with them and grow with them. And so, knock on wood, it's been semi-successful so far. Maybe it all falls apart. Maybe we become Texas and can't provide heat for our client community. I don't know. We're trying to winterize, and we're navigating this global pandemic like everyone else is. And not to give you a segue, but I'm at my home right now. So, we're in this with everyone else working remotely. The challenges of Zoom, the lighting in the background. One of my favorite Twitter feeds is Room Raider. And so it's a Twitter feed that shows he rates or she rates the different Zoom backgrounds of people giving this type of introduction or this type of podcast. And I don't think I would rate very high because I don't have any art or plants or cool posters. So I apologize that my room rating is 2 out of 10.
That's quite all right. I think anymore with Zoom, people are working from home. They're working from their kitchen tables. I had a nice visit with a guy the other day, and he's like, "Hey, I got an hour before my kids come home."
Yeah.
So I get it. So I'm super pumped to have you on today. I think your experience on both sides, on plaintiff and defense work, is going to help business owners and businesses today. Simply because of the fact, I mean, with your experience defending businesses, there's a lot of concern that businesses have right now as people have transitioned to home or working from home. And a lot of, I mean, even some of the larger companies I'm seeing, they are no longer going to have a physical presence. And some of them that are going to bring people back to work aren't going to do so until the end of 2021. So we've got a year and a half of people working from home. And I think from our original conversation, we don't even know what we don't even know yet, because some of these are yet to be litigated, or, we'll see how the claims shake out. But if it's all right with you, let's kind of dig in and talk a little bit about maybe some of the challenges that business owners face or that they may not even be aware of when it comes to remote employees. Is that cool with you?
Yeah, excellent. I think the preamble to any sort of conversation here is there are no laws written for this time, right? And the legislation in effect, especially governing workers' compensation, are not modernized, and they're not written for global pandemics. And the workers' compensation system in general is a quid pro quo, for where the employee, let's start with the employee gives up the right for certain common law damages. So there's no pain and suffering, there's no consortium claim, and there's no emotional distress. You don't get any money or compensation for those types of claims when it's a workers' compensation claim or workers' compensation injury. And so the employee gave up those damages for the employer not to challenge their negligence. So an employer cannot challenge an employee's negligence in getting hurt. So if the employee made a mistake, or the employee should have been aware of a wet surface and still fell anyway, it's usually compensable because the fault of the employee is not part of the causation equation. It's not part of the liability question of a workers' compensation claim. So that's the quid pro quo. And that's how workers' compensation laws have been developed over the time. But they haven't really been modernized into the modern workforce. The remote employee or the telecommuting employee has very little case law. And most of the case law we see is usually somewhat articulated under the coming and the going and coming rule, and has to do with transportation related issues with the remote employee. And so
when you talk about transportation related issues, just to clarify for the people that are listening, I assume you mean, hey, I'm at a convention in Las Vegas, or I'm at a convention, well, not in Texas right now because they're frozen, but those type of travel related things where people are injured at those type of events outside of the state that they normally work in.
Yeah, where they would travel for their company for a business related trip, or on a simplified measure, if you have an employee run to the bank to make your deposit, even that short of duration of trip. And so that's where we see a lot of the case law develop when we're talking about a telecommuting or a remote employee under the law. Probably the work from home industry has only really started to develop maybe the last 15 years. And it was very select few who worked from home. And so we just haven't seen those injuries manifest into a lot of case law. We do have some, and we can dive into that and what the relative factors are for those remote employees or telecommuting employees. And I think we'll do that. The primary principle in any workers' compensation claim is you have to meet the baseline question. And the baseline question is twofold. It has to arise out of and be in the course of your employment. And so before you can have a compensable workers' compensation claim, you must meet the basic requirements of having your injury arise out of and in the course of your employment. Arising out of, think of it as what an employee was doing at the time of the injury. And then in the course of, think about that as when the injury occurred. Mm-hmm. And so those two principles have to be satisfied for an individual to have a workers' compensation claim. And so when we start with a remote employee, they still must meet that the minimum requirements of having the injury arise out of and in the course of their employment. Both of those prongs are equally important, and you must satisfy both to proceed to any other questions under the statute. And that's universal. So whether we're talking about Iowa or California or Texas or Rhode Island, the basic premise of workers' compensation compensability is that the injury must arise out of and in the course of your employment.
Agreed. Whether it's the employee's fault or not.
Whether it's, fault is, we really don't ever look at, we look at fault very rarely. And usually we look at fault. Well, really the only way to look at fault in workers' compensation is intentional acts or intentional negligence, almost to simplify it, where they specifically say, the heck with that company rule, I'm going to do it anyway, and taking it and almost try to get hurt in a sense.
I had a conversation one time with an employer, and it starts out, "You're never going to believe this." And I listened to the story, and the employee had done something very stupid. I mean, it was obviously stupid. It caused damage. And I said to this business owner, I said, "I cover stupid every day."
Yeah. We have a great saying as defense attorneys. We say, "Stupidity is not a defense."
Nope.
And so unfortunately, oftentimes, because of the lack of knowledge of the workers' compensation statute, and because, I often equate workers' compensation as a language. I think of the law as a language, and I speak workers' compensation, and that's the same as someone speaking Spanish to me when I speak workers' compensation to an employer. And they'll say, "Well, he should have known this, she should have known that, she shouldn't have done that, she was really stupid on that." None of that matters because the statute doesn't speak that language, right? And so then I explain that, and they're like, "That doesn't make any sense." And I'm like, "I'm sorry, I know I'm speaking Spanish, but it's just one of those things where it's a very narrow section of the law. It's a statutory law, and it is governed by this quid pro quo that I explained at the beginning, where fault was taken out, and the employers took, they were willing to concede that because they don't have exposure to some of those damages like emotional distress or pain and suffering that can really escalate a value of an individual who's been harmed claim. So it's they've given up that. I don't know if that would go today. I don't know if employers would want to give up the fault. They may want the damages. That would be an interesting survey to give businesses. But it often infuriates my clients that the stupidity cannot be a defense, but it's not.
That's the struggle we have with a lot of work comp claims. And Sally or Joe, they were a good employee up until the day that they were injured. And suddenly something has changed, And I see it all the time where maybe the company will take a controversial position to the employee because it's like they screwed up when they got injured. It was an accident. And I think the reality is, as a company, our job is to make sure people come to work and leave work in the same condition that they came in. And it's our job to make sure that we have a safe environment. And if we see somebody doing something not safe, we should coach and encourage them. I think we also need to realize that workers' compensation is an employee benefit. We don't ever talk about it like that, but that's exactly what it is. We are taking care of our employees when they get hurt at work. And for the majority, I think, of most work comp claims, they're unintentional. They're not purposeful. Certainly, there are those claims that exist out there where maybe people are looking for money, but the majority of them just want to get back to work and have the whole thing be done. From what I've seen.
Yeah, I think in its true form, workers' compensation is an employee benefit. It clearly is, and businesses can obviously budget it. I'm a business owner. That's something that we budget. We shop for. We try to get good coverage with reasonable deductibles and reasonable premiums, and then that protects our employees from accidents. And if it's an intentional event, like I said, there's some defenses to that. The most valuable commodity my business has is its people. And I would argue that no matter what your business is, whether you're a law firm or whether you're constructing widgets, your most valuable commodity in your business is your people. And, we say all the time, and when we counsel our client community, and is, we need to, the major purpose of our work comp defense of a file is providing excellent medical treatment and getting that claimant returned to the workplace as quickly as possible. And I might accidentally say claimant every once in a while because I'm adverse, usually in my job, the injured employee back into the workplace as quickly as possible, because nothing good happens. Nothing when that injured employee is at home. Because think about it, when you are injured and you cannot go back to work because of your injury, you are losing a vital part of your social fabric. And so a lot of people are defined by what they do. And what they do is their employment. That is their definition. Their community is all intertwined with their employment. So if you remove that from them, they've lost their social network, they've lost their emotional intelligence, they've lost their empathy, they've lost their friendships, and now they're sitting at home. And the only thing that comes from that is frustration, depression, issues with, interaction with people they don't want to see for 24 hours a day. And they lose that purpose. And so, one of the things we always try to do as employers is return our people back to work. We want to get meaningful restrictions, so we can give them meaningful light duty work, so that we can have suitable work for them as they recover, so that they keep that social fabric. Most claims go wrong when the claimant can't return, when the injured employee can't return to work. And that's the primary issue. And it becomes a tension point, because sometimes the employee doesn't want to return to work because they think they're injured or they think it may impede the recovery. But it really, if you take all the factors into the calculation, into the formula, I think it's vital for employers to try to find suitable work for those temporary restrictions that the injured employee might have, so that they don't lose that social network. Which really leads us into, we're all now working like we're injured in a way, with restrictions saying you can't come to work. And so, it's maybe not as hidden as it's been, but I think, one of the trauma, or the biggest trauma of this pandemic, is the mental health of Americans and the mental health of our workers. And, we're not made to be isolated. as humans, and we're naturally curious and we're naturally social, and to varying degrees. Some people more social than others, but we have taken a huge subsection of the population and put them in homes to do their jobs, and that impacts the various social networks, and then all the restrictions that are in place around the country to limit what we do and how we get together for our safety. But at the same time, it's taking a huge toll, and now employers unfortunately will have to deal with how we reintegrate workers, and how we move forward in remote environments. And with workers' compensation, the laws are not written for this time, and so we're going to now have to deal with and investigate and litigate these claims that are going to arise out of and in the course of a remote employees' homework environment.
I know. Well, I don't want to get off topic here, but I think I read an article yesterday. Even the purchase of employment practices liability insurance right now, premiums are going through the roof because as people transition to work from home, lawsuits have increased for either wrongful termination or wrongful discharge or whatever it may be. And I mean that it's going to take a while for these lawsuits to work through the system. It's also going to take a while for all the COVID related workers' compensation claims to work through the system. How did you get it? Did you get it from work? Did you get it from your spouse? What if you're working from home? I don't know what the answer is for all those. It's above my pay grade, but I'm sure judges and attorneys, and they'll take it on nationwide. And I would hope there'd be some type of protection for business owners when it comes to COVID related claims outside of, maybe the unique health insurance industry. Obviously, they have a very high risk of COVID related claims being that they're working with COVID. But for the average employer, I don't know where that fault with them lies, especially if they don't know and they're trying to do as much as they can to protect people right now.
Yeah, obviously we deal with every day. Every day we have, questions or claims that come through that we defend or advise on regarding COVID exposure. And, how the law is written in Iowa is that an employee obviously must satisfy that arising out of and in the course of. But when we look, that's usually readily satisfied. They're at work and they're doing their job. They're doing their job at work. So they've met the rising out of it in the course of. So then we look at causation. And in Iowa, causation is going to be evaluated by, medical and legal, but it's going to show that the claimant must prove that it's more likely than not, at minimum, that his or her exposure to COVID happened at the workplace. And so there's legal terms like material and substantial, evidentiary wise, but to make it most simple, and I'm not giving any legal advice here, but to make it most simple is an employee must prove that it's more likely than not that they were exposed to COVID at the workplace. The way the law is written in Iowa, I would argue, and I'm not a judge, and I don't want to be one, but I don't see a clear pathway to compensability for the majority of COVID cases within in Iowa because of how our statute is written. Contact tracing is obviously a huge investigative tool that the employer has to undergo with every alleged claim of COVID. But COVID is what makes it so dangerous and so pervasive is that you can be asymptomatic and give someone COVID. And so that means any point of contact I have today exposes me to COVID. So I woke up this morning and I dropped my son off at one of my sons off at school. No exposure there because I was wearing a mask and he went out the back door and the teacher was, 6 feet away. So probably didn't get COVID from that interaction. But then I drove home. I picked up my youngest son and he doesn't have school today. So he's having a special day with grandma and grandpa. And so I put him in the car, and I'm going to meet my parents in Ankeny, Iowa. So about, 15, 20 minutes from here. But first we stop at Casey's and I fill up the gas tank. I'm wearing my mask, no COVID exposure there. I go in to Casey's though, because, hopefully my wife doesn't watch this, but my youngest son and I, we're going to get donuts, man. All right. So, this is a ripe opportunity, right? We're at Casey's, we're getting gas, and mom isn't with us. So you're darn right I'm going into Casey's. COVID be damned. All right. So I put on my mask, and, Casey's got a rule that everyone's got to wear their mask. I think everyone in Casey's had their mask on. I didn't look. I went straight to the donuts. I got some, wonderful vanilla with sprinkled donuts for my son and I. I'm not going to tell you how many in case my wife does watch this. And then I paid with the cashier. I'm clearly within 6 feet. We both have masks on. So I have probably a 90% chance of not getting it because of the mask and the 6, but I don't know the ventilation system in this particular Casey's. I walked by 3 customers, all with the same intent I had, to get either Casey's breakfast pizza or donuts. And I should note as a disclaimer here to my wife, I did not get Casey's breakfast pizza, so I was good. I only got donuts. And then I walked back out to the car and handed my son, his allotment of the donuts, and I kept mine. And we drove to Ankeny. We get to Ankeny, we stop in a parking lot at Menards. I'm not exposed to anyone but my dad. My dad did not wear a mask. He recently traveled back from Phoenix. Don't shame him. With my mom, they got away for a little while. They recently came back, so it hasn't technically been 4 days since they've been back, which means that he would not likely show symptoms yet. It's only been 2 to 3 days since he's been back. So most of the evidence says that you don't show symptoms if you're going to show symptoms until approximately 4 days. So we don't know if he's going to be symptomatic, if he was exposed or not. I was within 6 feet of him. I wore my mask. He did not. And we talked about how Iowa looked awful last night against Michigan. And we lamented that, can we make a run in the tournament? And is the season over if we lose to Ohio State this weekend? And so that conversation took longer than 5 minutes, but less than 15 minutes. So could I have gotten COVID today from my father? Yes. Now, if I go into my office today and I talk to my secretary for about the same exposure of 5 to 10 minutes, and she doesn't wear her mask and I wear my mask, could I have gotten COVID from my secretary? Yes. If I do test positive for COVID tomorrow, which one gave it to me? Can we say that it's more likely than not that I got it from my secretary? No, because it's equally as likely that I got it from my father. So I'm going to lose, or I should lose, the workers' compensation claim. And this is not a true example because I'm only using 1 day. We also know that we have to go back 14 days of interaction. And so we have to go backwards 14 days of every interaction I've had, both at work and outside the workplace. And now you see how the complexity of saying that it's more likely than not that I got COVID at the workplace, because every point of contact can equally be a point of exposure as the workplace can. And so that's why you've seen other jurisdictions across the country change, or by executive order or by legislative edict, say, look, we're going to have a presumption chain put into the law. You're presumed to have gotten COVID at the workplace. Now it's a rebuttable presumption. So some states like Illinois, I believe Minnesota, and maybe even like Kentucky and others have put in a rebuttable presumption. And what that means in legal terms is that it tells the injured employee, yes, you got it at work. So if you get COVID and you were working and you were exposed, you got it at work. And then the defense, we have to rebut that presumption. So we have to present evidence that says, no, there's better evidence out there that you got it from somebody else. And so we can still prevail that the workplace doesn't isn't responsible for the COVID exposure, but obviously by the law changing or the executive order changing the structure of the workers' compensation law to a rebuttable presumption for COVID, it makes it more likely in those jurisdictions that an employee would win a COVID case.
Okay, so this is news to me here. So what you're saying is let's use your secretary as an example. She tests positive for COVID. May have been caused by you, may have been caused by her kids, may have been caused by her trip to the grocery store. But that positive test she can bring back to her employer because she's working in the office and has had interaction with customers or coworkers, and then say, I got it here. Is that what you're saying, that the law has changed?
Not in Iowa.
Not in Iowa, but in other states.
In other jurisdictions, there's a presumption now. They've written into law the rebuttable presumption. The presumption is that if you get COVID and you were exposed at work, then it's compensable unless we can prove otherwise, unless we can present better evidence to show the exposure would not have been at work, or the responsible exposure would not have been at work.
All right. So I can get this from, I can wrap my head around this argument from a potential healthcare system who are dealing with active, positive COVID patients. I have a hard time wrapping my head around it when people do all of these other things and are going to grocery stores and are going to convenience stores and then blame their employer for their positive COVID test.
Yeah, I mean, you know, because of the asymptomatic nature of COVID, because you don't know if somebody has it or not, and then the lack of, frankly, the United States failure and testing universally under both administrations so far, and so the United States is so far behind in the proper testing and the ability to contact trace this the way you would need to get ahead of it. That's you know, we're just, you know, we've moved past that. Now we're in vaccination stage, so we're never going to have the testing required to actually control the pandemic in the United States. It's all fundamental to testing, and we just, you know, the government had a fail. If the government has failed at all in COVID, it's in testing, and we see that. I mean, that's, I don't think that's an absurd statement or even a controversial statement. We see in the countries that have successfully navigated COVID, they've done it through testing, and you know, we just skipped that, and that's why 500,000 Americans are dead. And so, you know, we are now into vaccination. That's good, and you know, there's arguments all up and down about what our herd immunity is and what our natural immunity is, and how many asymptomatic cases are really present. But yeah, that your contact, even, you know, I would argue even essential workers. I mean, there's a lot in the news about the meatpacking plants and the outbreaks that occurred there. And, you know, I think it's very easy to fall into the trap that says, you know, because I was working at a meatpacking plant, or I was working at even a healthcare facility or a nursing home facility or an assisted care facility, then it's more likely than not I got it there. Well, no. That's really not even an accurate statement. It's not logic. And I compare it to, like, if you've ever played roulette, right? I think that's the game. I'm not a gambler, but I've been to Vegas, and you know, I think the game was roulette, where they spin the wheel and it's black, red, black, red.
With a couple greens. That's the.
It's okay, and like you put, like, you bet whether you can bet on the number or whether it's going to be red, black, and stuff like that. And a great social experiment is to watch the betting people. And, you know, you put your money on black, right? And it's either going to be black or red. So you have a 50% chance, right, that it will land on black or red. They spin the wheel and it's black. And they spin the wheel again and it's black. They spin the wheel again and it's black. And let's say it's black 12 times in a row. Well, the natural human inclination is wrong. The natural human inclination is to say, it must be red next time. It's been black 12 times in a row. The odds are in its favor to be red. Now, it's still 50% chance that it's going to be black. So there's no greater chance that it's going to land on red the 13th time than it was the first time. The odds are still 50%. So really the play would be to stay on black, if you're going to play black, right? And so but that's kind of what we see with COVID and employees and the media sometimes is saying, oh, there's an outbreak at this particular facility. You must have got COVID there. Now, that's not logical whatsoever. What's logical is the contact tracing. What else are they doing? So they go to work, and yes, people at work had COVID. That's a fact. But a lot of the essential workers, unfortunately, live in multi-generational households. Mm-hmm. And those multi-generational households also have people working at other essential businesses during this time. And when they get home, are they staying masked? Are they staying within 6 feet? Do they have proper ventilation? No, I mean, it's winter. What if their kids are going to school?
Around my house and we're all sitting around the dinner table. I mean, we're family.
Yeah.
Yeah, I get what you're saying.
Yeah. And so just that exposure. Then if they go to Casey's, or if they go to Walmart, if they go to Hy-Vee, or if they go, out to eat, it's funny when we do this contact tracing, it's amazing how many people still go to casinos. And, I mean, I couldn't think of maybe a worse place to go during COVID, even though their ventilation systems are probably better. That same worker that might work at a facility that had an outbreak, when you go back 14 days with that individual, they have been to the casino, they go to Walmart, they've gone to gas, they haven't worn their masks certain times, they visited a friend, they, went tailgating, they've done this. And so, was it really work? No, it's just like 12 times in a row on black on that roulette wheel. Now the 13th is not going to be red. It's still a 50% chance. So that more likely than not, it makes it difficult.
So when you're defending a business against that COVID related claim, how does that conversation go? You can say, hey, they went to the casino, hey, they went out to eat, hey, they went here, but they also went to work. And if there's something already built into the code to assume, if there's something built into the state code to assume that they already got it at work, how do you prove they didn't?
Well, in Iowa, again, we don't have the rebuttable presumption. So in Iowa, it's just, we deny that claim because in Iowa, you can deny or accept your investigation. To deny or accept a claim has to be a reasonable investigation. And, you have
the insurance companies.
What's that?
Who's paying for that claim right now? Is it the insurance companies? And they're
well, if the claim is made in Iowa for a COVID case, I would argue that most of those claims are being denied because that individual, the injured worker, the COVID infected worker, can't show that it's more likely than not that he or she was exposed, that their COVID diagnosis was because of exposure at the workplace. And so really we that's why you haven't seen a lot of widespread COVID litigation in Iowa, come forth. And there's some highly publicized COVID exposure outbreaks at some meatpacking plants in Iowa that I'm sure is being litigated. But it's, from an evidentiary standpoint, I think it's a very difficult case to prove in Iowa. Now, if it was a rebuttable presumption jurisdiction, where it's presumed that they got COVID because of their exposure at work. I mean, they have to satisfy the prong that somebody at work had it and they were exposed to that person. I still think you can win that case, but I'm a defense attorney, so I'm always going to think you can win that case. But you're going to do contact tracing. I mean, you're going to have to prove that that exposure at work was less likely than additional exposure that the claimant had. And that's going to be difficult. That rebuttable presumption is going to favor the employee in those jurisdictions over the employer. That's why they changed the law in those jurisdictions. Those jurisdictions wanted the employer to cover that loss or that claim.
Well, I think anytime you have hourly workers who are, if they're quarantined because of COVID and they're not getting paid, I know that, I think in the first round of PPP, businesses could pay employees to stay home for the 14 days that they were quarantined, but that funding ran out. And so I think it's a hard conversation right now for any legislature to say, hey, we've got all these people who aren't getting paid, who are being forced to stay home. We need to do something about it so they get reelected. Therefore, they change the law and they put that burden on the backs of the insurance companies, whether
Correct.
so or not. But then what I'm hearing you say is now the insurance companies are going to pay you. They're going to pay for contact tracing. They're going to try and do everything. Or maybe it's just easier to pay the 14 days of wages than to do all that other stuff.
Yeah, I mean, it really is. It's employer directed. I mean, the employer can pick it up under the policy if they want. There's obviously evidence that it could have been compensable because the exposure occurred at the workplace, and most of these claims, like you say, are very minimal. Maybe they miss 14 days of work, and so they meet the waiting time, and they get a couple weeks of benefits, and then they have no other symptoms, or they weren't put in a hospital. But then also, if you set that precedent, what happens if you accept the claim that unfortunately the individual becomes symptomatic and not misses 14 days, but misses 6 months, or ultimately, unfortunately dies, or or you have a long hauler. What we don't know also is we don't have the data or science developed yet with what the long hauler effects are from a COVID diagnosis. We think, if you're not symptomatic, that you'll be maybe okay, but are you going to be more prone to heart disease, or vascular conditions or neurological conditions? And we won't have science or data for that for a few years. But in workers' compensation, we have something called the sequela of the injury, and the natural consequence of the injury is still remains compensable. And so you see that sometimes with, like, if I injure my right shoulder and I'm right-handed, so I start doing everything left-handed while I'm recovering from my right shoulder surgery. Now all of a sudden my left shoulder starts to hurt, and the doctor says, yeah, you're overusing your left shoulder. Now that one needs to be repaired. Well, that can be compensable through the natural consequence of my injury, the sequela of the injury. And so my right shoulder and left shoulder are now the work injury, even though I only injured my right one at work per se. Well, COVID, you could argue, a good attorney would argue that, hey, my client is now having a neurological condition. My client is now having a vascular condition. My client is now having a cardiology condition. And that is the natural consequence of the COVID diagnosis. And so, then all of a sudden that claim gets really expensive, and can be, a claim that's going to be open for a very long time. And if you know anything, right, if we know anything about workers' compensation from the employer perspective and the insurance carrier perspective, is the longer the claim open, the more expensive that becomes, and the more burdensome that becomes on both the company and the insurance company. And
I think what you bring up a big point here that we're probably not talking about in the workspace enough right now, but there certainly is a lot of fear amongst insurance companies when it comes to workers' compensation on what the tail is for these claims. So, well, once again, we're fortunate in Iowa that that's not the jurisdiction that we have, but in some states that are passing pro-employee COVID legislation that's putting this burden on insurance companies. I mean, for the first time in years, we are seeing workers' compensation rates increase across the board nationally. After they've stair-stepped down for probably 6 or 7 years, and there's a lot of fear. Just what does that look like? And if there are death claims, there are serious issues. How long does that last? And I mean, I think with anything unknown where you have a payer, and in this case, the payer is the insurance company, they're very fearful at what they may have to pay out, how that affects their solvency. They're looking at reduced premiums right now simply from the shutdown of the economy, and potentially larger payments going out next year. I don't know what that looks like. I hope our federal legislature does something to protect not only businesses and insurance companies and people, but what that looks like, you're right, I don't know.
yeah, it's a complete unknown. And that you use the proper language here. The tail is going to be scary. And how do underwriters assess that? And that, and that's going to be, I mean, because the one thing we know about the one thing that's speculated about COVID is that it impacts other, other primary systems within the body. And so it's not that, you know, unreasonable for a claimant attorney to start saying, look, my individual got COVID. Now he's having difficulties with his liver, or she's having difficulties with her vascular system. And to say that's the natural consequence. And then, all of a sudden a claim that should have been 14 days and no hospitalization on that, it turns into, a 6-year claim where they're in pain management or chronic medication, or that leads to a mental health condition, and that becomes a very expensive claim that wasn't anticipated, obviously, by the policy at the time it was written. But now you have a tail, and maybe you're a small business. I mean, no business is protected from COVID. So if you're a small little business, your mods are going to skyrocket, and you could have very unaffordable workers' compensation insurance, and large companies obviously would see more profit loss towards that. But and if we've learned anything over the last probably 6 to 8 to 12 years, is the federal government is inadequate at responding to anything. And so compounding any sort of global pandemic, unfortunately, is the healthcare system in the United States is a wreck. And so that I'll probably get on a soapbox here, but that impacts workers' compensation, because unfortunately, workers' compensation, a lot of times individuals think it's health insurance, and it's not. And everyone though puts their toe into the water to try to get a piece of that reimbursement from the carrier, because we have inadequate healthcare in the United States. And there's probably a political solution, but it's not possible without politicians. And I speak to Democrats and I speak to Republicans.
I think that's the conversation there. I mean, each state is going to have different legislation based upon probably each party affiliation. I mean, you're going to have 50 fragmented outcomes in terms of workers' compensation, stay-at-home, COVID-related claims, just by the nature of how state legislation works.
Yeah. And workers' compensation is inherently a state system. There's no federal regulation of workers' compensation. There's no entanglement of federal legislation with workers' compensation. There's been a big push over the last probably 10 years by certain interest groups saying that it should be workers' compensation should be federalized. And I think you could see, as a result of COVID and different states' response to it, that maybe there's even a greater push to do something federally with workers' compensation. Myself, I don't think that would be good. I think state is better at managing workers' compensation. A state system is better at workers' compensation than a federal system, because states are so diverse in their economies. And so certain systems can adapt to those economies better at a state level. Because Iowa by no means is California, and North Dakota by no means is Iowa. And so to have the ability for that state to control their workers' compensation laws and systems is, I think that's good for all stakeholders in workers' compensation.
Yeah, I would agree. I think a federal system for workers' compensation would not only increase cost, it would also hurt injured workers.
I agree.
Yeah, and it would deliver a poorer outcome than what we have today. And I think we have a lot of carriers out there that are really trying to create a better experience and do the right thing. And certainly Iowa, where we're domiciled at, has some of the lowest workers' compensation rates in the country, compared to Los Angeles County, which are the highest rates of anywhere in the country. And I certainly would not be in a position to advocate for any business here that we should subsidize businesses elsewhere because of their legal climate.
Yeah. I mean, Iowans are good people, and the Iowa NICE is real, and I think also we have access to elite medical services throughout the state. We're really blessed as Iowans to have opportunities for treatment at world-class institutions that are within a couple hours from us. And that's a really, in many states, you don't have access to that level of medical care. I mean, we can send pretty much anyone in the state to either Mayo or the University of Iowa if they have an injury that requires that. And then we also have Des Moines and Omaha with, elite institutions, and they're never you're usually within 3 hours at the most of any of those institutions, or one of those institutions, no matter where you're injured in this state, which gives you access to some of the best surgeons and physicians, in the world. And that's a great thing. If you're injured in Iowa, is you can get world-class treatment for that injury and get a good outcome. And that's not always the case in states.
No, that's true. Well, we covered a lot of ground today, Kent. A lot of ground.
Yeah, except for, I feel like I left out the remote employee.
That's how it goes sometimes. So we were going to talk about remote employees. Instead, we talked about COVID and some of the legal challenges surrounding COVID, which I'm sure there'd be a lot of businesses that would like to hear about some of those challenges. And, even for me in Iowa, I was not aware of some of what was happening in other jurisdictions. And so I certainly think that there's businesses in those states and even insurance agents in those states that may want to be talking to their policyholders about what's happening at the legal climate and what they need to do. I shudder to think if I'm a business that causes COVID, or somehow through lax practices, one of our workers gets COVID and becomes ill or high medical bills, or turns into one of those super claims, let's say, for whatever reason. That opens up the door to third-party overactions from spouse and family and all sorts of other things that are going to be not only are they costly, but it's a bad outcome for a bad situation, I guess, is what I want to say.
Yeah, employers, I think, are trying to be as innovative as possible right now to stay in business, serve their clientele or customers, and do it in a safe environment for their workers. And there's been billions of dollars, if not trillions now, of funding that's been approved by the federal government to help employers. Some of that billions are to help employers make a safe environment, and there's some funding even via state. But the thing about COVID is it's the only really effective tool against COVID is not to expose yourself to another individual. And we can increase the safety by mask wearing and plexiglass and spacing and ventilation. But the employer cannot guarantee a COVID-free environment ever, even with rapid testing. I mean, we probably the most secure place in the world is the White House, and they had an outbreak, and it only takes one person not to wear their mask. It only takes, one individual to make a mistake and expose many. And that's a tremendous challenge on a business then to operate, safely and without, exposure. At the same time, that individual has to live, and that individual employee is commuting back and forth. They're going, they're living life the best they can too. Their kids may be in school, their kids may not be in school, and you have to go to the grocery store. You might not have access to delivery. And so, the best thing is we can all get vaccinated and hopefully, lower the exposure point, and most importantly, the vaccination can help prevent serious injury. And that would be a welcome change to it. And there's positives. I mean, the rates are dropping now, and more people are going to start going back to work. And hopefully we can, have comprehensive federal legislation that protects employers, protects employees, and doesn't shift burdens of cost to the private sector that shouldn't be there, because those are always passed down then to the individual, right? And so very rarely does the employer or the company actually pay for those. They're passed on in the premium dollars and other services that are rendered. So there's no easy solution, and I don't envy anyone trying to make those solutions, but as an employer, we do the best we can. We require a mask, put in plexiglass, make sure you're 6 feet or so spaced, and work from home if you can. And so yeah, it's been an interesting global pandemic over the last year and a half, or year now. It feels longer.
Yeah. Hopefully we can get back to some sort of normalcy real soon.
Yes, they would be welcomed.
All right, Kent, before we wrap up here, 3 questions that I have for you. What are you reading right now?
I am reading, I don't know. Let me look. I am reading an author by the name of by Jack Mars. Primary Command is the book. I am my guilty pleasure is reading spy novels or action novels. So I read them all, and now I'm on Jack Mars. I guess they're okay.
They're okay.
They're not Tom Clancy, but I it's kind of my outlet. I read all that genre, so I read a lot. I like to read, but
Great, because I am a huge James Bond fan.
yes, I love Bond.
And whenever I see a Bond movie, except for Timothy Dalton, I mean, I'll watch almost any other Bond movie except for those. And it's the same story, right? It's spy, fast cars, beautiful women, get the bad guy, stuff blows up along the way, and we all win. And it's the same story again and again and again. And every James Bond movie I watch, everyone.
I just rewatched all the Daniel Craig ones.
Yeah, he's awesome.
And that, because I want the new one is keeps getting delayed, but that was, yes, I like those types of novels. It's my guilty pleasure, and I read those.
All right, so number 2, what are you spending more money on than you should right now?
Home improvement.
Country when you say that.
It's yeah. I mean, yeah, I'm like everyone else. We found the flaws in our home, and instead of ignoring those flaws, now we are more likely to spend money to repair or fix those flaws. And I don't have the excuse that I'm too busy or not at home or have to be gone for a couple of days. So I'm not handy either. So that's why I spend too much money. It's home improvement by far.
Okay. All right. And last thing here, we just asked you to give a piece of advice or your thoughts to the world. Kent speaks and he says,
I don't presume to tell people what to do. I make suggestions, you make decisions. But and that's a quote, I guess, from that's not attributable to me. But that's attributable, I think, to Dennis Morton. He's a Peloton instructor. So I like when he says, I make suggestions, you make decisions. That's all I can do is make suggestions. Be kind, be respectful, be polite, and we do those 3 things, we'll probably be okay. But they're just suggestions.
yeah. Hopefully people will take that under advisement. Hopefully it helps their mental health. And we're all distancing, we're all far apart from each other. Kindness is key right now, because you never know what the other person's going through.
Yeah, no, I agree.
All righty. Kent, I just want to say thank you again for being on the podcast today. If people want to get in touch with you, what is the best route for them to do that?
They can email me. I guess what social networks I have, they can contact through those. I don't know the lingo to tell you what that's called. But I'm on them except for Instagram, and you can always visit our website. Our firm's website is smithmillslaw.com.
All righty. Perfect. All right, we're going to wrap this up. Thanks again, Kent. And thanks for all you listeners out there. Let's make it a great day.